it depends on the nature of the relationship. It depends on the nature of the problem. As I stated, if it's something that the client can live with, then just because it's unconscionable technically doesn't mean that practically it's the best thing to do to breach whatever obligations that the client has. So you have to determine what the client's goals are, what terms that they can perform or that they're willing to perform, and what terms that possibly they can't perform. And if it looks like it's going to be something that the other side is going to have an issue with, then the best course of action, I think, is to approach the other side and say, hey, look, we understand that this contract was executed by both sides. We understand that it's not illegal in nature or for a variety of other reasons, but it may be voidable because of the fact that it's unconscionable. So we don't have to perform at least some of the terms or obligations within the contract because it's unconscionable, and try and see if you can negotiate that after the contract's been executed. And sometimes that's successful. And then, like I said, you could go to and file an action and try and get a declaratory judgment to have a judge determine that it's unconscionable before you actually have an issue and the other side files suit for a breach. Then you go ahead and you ask the judge to determine that it's unconscionable from the get-go. And if that's the case, then the other side knows that they can't really bring an action because the judge has already determined that the contract is unconscionable. And then the third is kind of the wait and see approach and wait for the other side to sue and then raise it kind of as what's called an affirmative defense and say, all that may be true. You had a legal contract from all other perspectives, but it's unconscionable in nature. So even though we executed it, we don't have to perform. So that's what I would kind of go through with the client, see what the best option is for them.